Hello all, I'm SAI LAKSHMI SURAJ. I'm interning under ubAdvocate, and in this video, I'll be speaking about the topic confession of co-accused, which is covered under Section 30 of Indian Evidence Act. So we'll look into what Section 30 speaks about. It speaks about consideration of proved confession affecting persons making it and others jointly under trial for same offense. So the section reads like this: when more persons than one are being jointly tried for the same offense, confession made by one of such persons affecting himself and some other of such persons is proved, the court may take into consideration such confession as against such other person as well as against the person who makes such confession. So the section basically states that when two or more persons are being jointly tried for the same offense, and if one of the accused makes a confession which affects himself and as well as the other persons, then the court may take into consideration such confession as against the person who makes it as well as the other persons who are being jointly tried with him. And in the explanation, it says the offense under this section includes abatement and also attempt to commit the offense. So we'll break down the section into parts. First one is when more than one person is more than one person should be there and they should be jointly tried, and that too for the same offense. These three are more like prerequisites for the section 30 to come into picture. That first one being there should be more than one person and they should be jointly tried, and that too for the same offense. And if one of such persons makes a confession which affects himself and also the other person who is being jointly tried with him, then the court may take into consideration such confession as against the person who has made it and as well as the other person. The general rule in England is that the confession can only be proved against person who makes it, not against the others. But according to Section 30 of Indian Evidence Act, confession made by one accused can be proved as against other accused in the joint trial. The basis for this rule is that he implicates himself as long as along with others for commission of that offense. This self-implication give some sort of guarantee for the truth in this confession. When he makes a confession, he's implicating himself for the same pains and penalties as like the other person. So such confession is taken into consideration. But this is obviously not a weak, it is a weak guarantee. And there are 5 conditions for section 30 to come into picture. First one being there must be joint trial for 2 or more persons. Second one, joint trial must be permissible under law. Third one, joint trial must be for the same offense. Fourth one, statement must amount to confession. Fifth one, court may take confession into consideration. So we'll look into first condition, that is there must be joint trial for 2 or more persons. The confession given by one accused can only be taken into consideration only if there is a joint trial. And in these cases, confessions will be taken as inadmissible. First one being, the confession is made before he was charged for an offense or after withdrawal of the case or the person is undergoing sentence of imprisonment. In these 3 cases, if the co-accused is made a confession, it will be held as inadmissible in court. It will not be considered as a valid confession. If the co-accused is discharged and if he did not undergo the trial, then also if the accused makes a confession, it will not be a valid confession. And if the co-accused died before the trial or during the course of investigation, and if the deceased person is making a confession, that also cannot be used against the other person because there was no joint trial for it. And there's a case law regarding this point, that is Badri Prasad Prajapati and etc. versus State of Madhya Pradesh. In this case, the accused, his name was Mahendra, and he took Mr. Badri Prasad Prajapati's name during the investigation. But before there was a joint trial for both of them, the accused dies. So in this case, the court is held that as there was no joint trial, the confession made by one person, the co-accused, cannot be used against the other person because there was no joint trial for this case. Second one is joint trial must be permissible under law. So confession of the co-accused is not a substantive piece of evidence. It needs corroborative evidences in support of it. So if the judge is inclined to accept the plea of guilty with an intention that this confession of the co-accused can be used against the other person who has not pleaded guilty, then this trial will be held as unlawful or unfair legal process. Next one is joint trial must be for the same offense. The same offense in the section in this condition means offenses within same definition and same transaction. It is not necessary that person shall be charge sheeted under one and same sections of IPC, the different offenses which has been committed in the same transaction, for those also we cannot call it as same offense. For example, we'll take if a person is charged of an offense like murder, we'll say if A is accused of murder, that comes under section 302 of IPC. And if other person is accused of disposal of the body, which comes under section 201 of IPC, the joint trial cannot be done for it because it's not same offense which has been committed. It comes under different sections of IPC. Or we'll say A is accused of theft, which comes under 380 of IPC, and B has received stolen property, which comes under 411 of IPC. In this case also, it cannot be said that joint trial, it is not the same offense. So the joint trial cannot be done, as it's not the same offense. Or we'll say if A is accused of murdering C, again, murder comes under 302, and B is accused of instigation of A as well as murdering of C. Then in this case, we can say that joint trial is permissible under law because it's all the same offense. There's a common offense for them. Yeah, and in this section, it states the same offense include abatement and attempt to commit the offense. Next is statement must amount to a confession. First of all, there should not be any ambiguity in the confession. The statement is confession, and the statement must implicate himself to the same degree as to the other accused. The person making such confession must implicate himself to the same degree or proportion as to the co-accused. If he implicates himself into some petty offense and the other person to some major offense, it cannot be said that it is a valid confession, because the basic rule for this confession of co-accused is that he must implicate himself and the other person to the same degree. And next is court may take such confession into consideration. According to the discretion of the court can either consider or reject this confession of the co-accused, but it cannot be exercised arbitrarily. Generally, the court is reluctant to accept such confession without corroborative evidences. As I said, it is not, the confession of co-accused is not a substantive piece of evidence. It needs corroborative evidences in support of it. So the evidentiary value is extremely weak in absence of corroborative evidences. Now we'll look into evidentiary value. As I said, the evidentiary value is extremely weak in absence of corroborative evidences. It was held in this case, Pancho versus State of Haryana. The court has held that the confession can only be used to confirm conclusion drawn from the other evidences. And the trial court cannot begin based on the confession of the co-accused, the court may analyze the evidences, and if satisfied with the guilt of the accused, then it can take the confession into consideration and draw the conclusion. And it is not obligatory on the part of the court to accept the confession of the co-accused. It is completely on the discretion of the court. Thank you.